Mr. Kpobi, we would like you to tell us what plea bargaining is to the ordinary man.
To the ordinary man, they take plea bargaining in Ghana to be just like how we go to the market and we bargain. You want to prefer charge against the accused person, and they come and then they tell you that they will prefer if a lesser charge is preferred against him based on some stated reasons. So basically, it's not different from the legal requirements. Yes.
When you say different from legal requirements, what do you mean?
The legal requirement is when you are charged with an offense, let's say a higher offense, you can make a proposal to the prosecutor and the court that you prefer a lesser offense to be preferred against you, whereby you plead guilty to that lesser offense. Not that lesser offense will be preferred against you and then you be tried. You go to the trial. You will not go to the trial. So it means that whatever lesser offense you want to be preferred against you, in place of the higher offense, you are ready to plead guilty to that offense. So more or less, you are admitting that you've committed an offense, but not that higher offense that you are being charged with, but a lesser one. Let's say it is murder. You can tell the prosecution that no, I think manslaughter, whatever I did will be manslaughter. So I'm proposing that we bargain so that I'll plead guilty to manslaughter. Because we are bargaining, you bring something onto the table, the Republic or the prosecutor will bring something onto the table. So what the prosecutor is bringing onto the table is that he will reduce the offense from a higher one to a lesser one. And what you are also bringing to the table is that you accept that, yes, I'm guilty of that lesser offense.
So, can we create a hypothetical situation to illustrate the concept?
Yes. Not even a hypothetical situation, because I've done several of them.
Okay.
As a prosecutor.
But where we can situate it within the plea bargain. As at then, it was not.
No, as at then, it was still a plea bargain. But just that it was limited to the offense of what? Indictable offenses.
Oh, okay.
It's not extended to summary trial, but limited to indictable offenses. Section 329, Section 239, subsection 2 of Act 30. That is the Criminal and Other Offences Procedure Act 1960. Act 30.
So the plea bargaining Act, that's the amendment to Act 30. What is it intended to do?
Yeah, what it is intended to do is that it is expanding the scope. As I said, hitherto it was limited to trials on indictments. For example, if you are charged with the offense of murder, which is punishable by death, you can make a plea bargain or can bring a proposal that, oh, I think if you charge me with manslaughter, which is punishable by life imprisonment or any lesser term, I will plead guilty to that lesser offense. So it goes like this. If everything is agreeable, you must talk to prosecution, you must talk to the judge. You at times you even agree on the sentence. And then you go to court, they will call the case, they will read the charge of murder, and then he will tell the court, not guilty of murder, but guilty of manslaughter. They did not prepare a different charge sheet for the lesser offense that you'll be pleading to. Do you understand?
Yes.
They will read the original offense, let's say murder, contrary to section 46 or so. Are you guilty or not guilty? Then you say, I'm not guilty of the offense of murder, but I'm guilty of the offense of manslaughter. That's how it goes.
I see.
And the court will record it.
I see. But before that, there will be a pre-arrangement with prosecution.
Yes, and the court as to the sentence.
Okay.
Because it's part of the bargain.
Yeah.
As to the sentence.
Yeah. Okay.
As to the sentence.
So respectfully, what then would be the positives this amendment to Act 30 would be bringing?
A lot of positive outcomes. The first one is that the time period that will be wasted on trials, it will reduce it drastically. I prosecuted a manslaughter case before, and the person was there for 18 months. You understand? I prosecuted another case. The person was I think raped. The person was there for five years. So at times the offense would be very serious, and the person fearing the outcome will not plead to the charge and will go for a long trial, knowing that if committed offense, but when it comes to plea bargaining, they will bargain even. It is only the plea, but in actual fact, when it's being done, you bargain the sentence too. If they are agreeable, they go in. For example, if I'm guilty of murder and it is death, but you know that Ghana right now they don't carry out the death sentence.
Yeah.
So you'll be there to some time, then you'll be given this thing. What if you come and do plea bargain and I tell you, then it will be life imprisonment? So that one may even stop you. But if I tell you maybe 30 years imprisonment or 40 years, maybe you realize 40 years, okay, or so eventually most of those in custody or those who are facing charges, they come forward to plead. Let's say if it is, usually what I have experience with is the murder and manslaughter, that area. For example, the first time we tried it in Sunyani, personally I'm speaking from my own, we had a lot of people, and then even the week, some they've been in for 10 years, 8 years, 12 years.
So these are remand prisoners?
Yeah, remand prisoners. So we look at the situation, at times getting witnesses was even difficult. So I told the prison officers that there's a plea bargaining. So those who've been in for a long time and they are even finding it difficult getting lawyers and all the rest, if they want, we can try plea bargaining and see. And they didn't know what it was. But eventually one of them was bold to come forward, and there was a plea bargain. And I think he'd been in custody for 12 years as at that time. So we did a plea bargaining, and it was reduced to manslaughter. And we agreed that he'll be sentenced to 15 years. And he was sentenced to 15 years. So he had about 3 more years. The number of years he served was taken into consideration.
So you'd agree with the memorandum to the Act which says this amendment would help to decongest our prisons?
I agree with you. It's in the right direction. It's very true. Because that exercise that we carried out in Sudan, that was in the year 2005, if my memory serves me right. I think about 15 prisoners went for plea bargaining. About 15 prisoners went for plea bargaining.
I see. But don't you think it may pose a little bit danger to our criminal justice system?
No, it will not pose a danger. It will rather assist the justice system. It will decongest the courts, and then there will be time to deal with the very serious cases. And let me tell you, it is not every case that you bring for plea bargaining that the prosecution will agree.
Yeah.
Some are very heinous, they will not agree. No, they will not agree. It's not every case. If it doesn't merit plea bargaining, they will not agree.
But do you think that's, and this is not do you think, because you have knowledge of the bill, do you find that a person convicted and appealing same conviction has the opportunity or right of plea bargaining?
No, on appeal?
Yes.
No, I've not come across plea bargaining on appeal.
On appeal. I want it to be clear that, because people who, when news of this is out there or the bill becomes law, people may be under a misconception that it affords somebody who is convicted already the opportunity of rebargaining or entering a bargain when his matter is on appeal, or because of that he may want to appeal and try to assert a right of bargaining?
No. If you are already a convict, you can appeal against sentence, and then they will look at the sentence. So I think that avenue is already there.
So there's
you
no
appeal
avenue
against sentence for the court to look at your sentence, and then if there's anything that can be done about it, the appellate court will do that.
So the opportunity exists for trial at the first stage only?
Yes, trial at the first stage.
All right, sir.
And nothing more than that.
All right, sir.